Developing intellectual property takes time, energy, and resources. You've spent months, maybe years, building up your intellectual property. Sweat, tears, late nights, and probably a decent chunk of your budget have gone into making your ideas tangible and valuable. But the work doesn't end there. Once you've got your shiny intellectual property in hand, what's next? The answer is a solid licensing model. By putting a smart licensing model in place, you can give other businesses the legal means to use your intellectual property, while making sure that you get your fair share of the profits. So let's dive in and unpack how to make it happen. What you need to know about licensing agreements. A license agreement is a legal contract between two parties, the licensor and the licensee. You, the licensor, own some form of intellectual property, be it a patent, a piece of software, or a design. The licensee is the company that wants to use what you've created, but legally and with your permission. If you have a software product, then you'll need to become familiar with software license agreements. These are a subset of regular license agreements designed to deal with the complexities that come with licensing software. Let's say you've developed a groundbreaking app. A software license agreement outlines who can use it, how they can use it, and what they owe you in return. You can detail everything from the number of users who can access the software to limitations on reverse engineering your code. A guide to different forms of intellectual property. Depending on your situation, you could be dealing with various types of assets that fall under the umbrella term of intellectual property. For instance, if you've invented a new machine or a device, a patent license would be your go-to. If you've created a brand logo or a name that you want to protect, you'll be in the realm of trademark licenses. If you've authored original content, a copyright license is what you need. Tailoring the licensing model to fit the type of property you have is a vital step in ensuring that you reap maximum benefits, protecting your intellectual property. A license agreement is more than just setting fees or specifying usage rights. It's also about outlining what happens if things go awry. What are the penalties for breaching the contract? How do you audit the license to make sure they're complying with the agreement? What are the conditions for terminating the agreement? Laying out your licensing model. First, consider flexibility. Your model needs to be agile enough to adapt to market trends or new innovations. Next up is your revenue structure. You'll have to decide whether a flat fee, royalties, or a hybrid of the two suits your financial goals best. Term length is another crucial factor. You could go for short-term licenses, giving you room to renegotiate terms regularly, or opt for a long-term arrangement that provides more consistent revenue over time. Finally, there's the question of exclusivity. Granting exclusive rights to a single entity can fetch you a higher fee, but you're also tying your fortune to one partner. On the flip side, non-exclusive licenses spread your risk, but might bring in less money per license. Now that you've learned a little more about license agreements, it's time to start your planning. An intellectual property lawyer will be your best friend along the way. Berkeley Law and Technology Group is here to help you create a successful licensing model for your future. Contact us today.